Before we start with evidence, Mr. Beer, I have another sad announcement to make. I have to inform all those who are following the inquiry that one of our core participants, Mrs. Carol Riddell, died on the 25th of October. Mrs. Riddell became the sub-postmistress in her home village of East Bolden in the northeast of England in 1991 and continued in post until 2000. She was therefore in post when Horizon was rolled out, and she found dealing with Horizon particularly difficult. As a consequence of that and her own ill health, her husband, Alan, took over as the sub-postmaster in 2000 and continued in that post until 2013. During her time as sub-postmistress, Mrs. Riddell had to contend with a very serious armed robbery at her post office, during the course of which she was blinded by having acid thrown in her face. In latter years, and perhaps for many years, both Mrs. Riddell and then her husband Alan were assisted by Miss Jean Smith, who was a very close family friend and assisted considerably in the running of the post office until in 2013 their involvement ceased. All three of those persons, well, Mrs. Riddell was a co-participant, and Mr. Riddell and Miss Smith remain co-participants at the inquiry. Mr. and Mrs. Riddell were claimants in the group litigation. I'm sorry to have to report that neither had received full compensation under the relevant scheme as of today. On behalf of all members of the inquiry team and on my own behalf, I extend deepest sympathy to all Mrs. Riddell's family and friends. Over to you, Mr. Beer.
Thank you, sir. Before I start with the evidence of Mr. Hollinrake MP, just two short matters. Firstly, some clarification of the evidence of Simon Recaldin that he gave on Monday. On Monday, the 4th of November, Mr. Recaldin gave evidence about the current position of assistants and managers of postmasters who are unable to claim under a redress scheme for shortfall payments made. Mr. Recaldin said in evidence, the transcript reference for Monday is page 50, line 16, that the position was under consideration by the Minister. The inquiry was informed by letter from the Post Office's solicitors yesterday that this evidence was, in the words of the letter, quote, not quite correct. Instead, and I again quote from the letter, there have been discussions with DBT officials in this regard, although the Post Office is not aware of anything formal under consideration, end quote. By its letter, the Post Office apologises for what it describes as the confusion in this regard. The second announcement, sir, is that at 10 o'clock, I'm afraid we've got the fire alarm. It will be in the course of Mr. Hollinrake's evidence, and so I propose that we sit here, or in my case, stand here, rather awkwardly for 5 minutes whilst that's got out of the way.
Well, perhaps I might invite you to sit down, Mr.
That'd be very kind, thank you, sir.
Right.
With those 2 points, may I call Mr. Kevin Hollinrake, please?
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Good morning, Mr. Hollinrake.
Morning.
My name is Jason Beer. Can you give us your full name, please?
Kevin Hollinrake, Member of Parliament for Thirsk and Moulton.
Thank you. You've made kindly a witness statement for us, which should be in hard copy in front of you. It's dated the 7th of October 2024. The URN is WITN 11460100. It's 17 pages in length. I think there's one correction to make. If we turn to page 12, please. It's at tab A2, I think, for you. So page 12 and paragraph 44.
Yes, got that.
About 4 or 5 lines in,
Yep.
it says in brackets at the end, as I think there were 200 people earning over £100,000 a year, do you wish to correct that figure to 143 people?
Yes, that was from memory. It's 143, having seen the actual documents that I was given at the time.
Thank you very much. So cross out at 200, add 143. And if you go to the last page, which is page 17, is that
Yes.
your signature?
It is.
And with that correction brought into account, are the contents of the statement true to the best of your knowledge and belief?
Absolutely, yes, they are.
Thank you very much. Can we start, please, with your background, Mr. Hollinrake? I think after a career in business, you were elected as the Member of Parliament for Thirsk and Moulton on the 7th of May 2015.
That's correct.
You served as a Conservative backbencher for 7 and a bit years until on the 27th of October 2022, you were appointed by the then Prime Minister, Rishi Sunak, as Parliamentary Under-Secretary of State in the Department of Business and Trade.
That's right.
And then you were promoted to the position of Minister of State on the 26th of March this year, 2024, being Minister of State for Enterprise, Markets and Small Business. Is that right?
That's correct.
A position you held until the 5th of July 2024, when a Labour government was formed on that day as a result of that general election.
That's correct.
Is it right that in both positions, both as Parliamentary Under-Secretary of State and then as Minister, the Post Office Limited was amongst your wide portfolio of responsibilities?
It certainly is. Yep.
And so, in short, you held ministerial responsibility for the Post Office in government for 1 year and 8 months between October 2022 and early July 2024.
Yes, I did.
Thank you. In opposition, I think you held, so after July 2024 until today, and in fact until yesterday, you held the position of Secretary of State for Business and Trade.
That's right.
But I think the new party leader, Ms Badenoch, appointed you yesterday to the role of Shadow Secretary of State for Levelling Up Housing and Communities.
That's true.
Can we please look at your witness statement? It's page 3, paragraph 6.
Yep.
Paragraph 6, 7 and 8. It will come up on the screen as well. In the preceding paragraphs, you've set out the extent of your ministerial responsibilities. But you say in paragraph 6, during my entire time from the 27th of October 2022 until the general election in July 24, the Post Office fell under my ministerial remit. And as part of this, I was responsible for leading the government's actions on redress for sub-postmasters and post office reform. This was my number one priority as Minister, no question about it. It was of key importance to the department, and it was also an issue which I cared about personally from my time as a backbencher. My appointment was manna from heaven to me because it meant I could actually help to fix something important. There wasn't a day, night or weekend that went by when I wasn't doing something on the post office redress schemes and transformation. I would say at least 25% of my overall time, and during many periods a much higher percentage of time, was focused on this. you speak there about the post office being an issue about which you cared personally from your time as a backbencher. Can you help us? Can you explain why that was?
Well, my life's been small business. So one of the nice things about being a Member of Parliament is when you, from the backbenches, you can speak on virtually whatever you'd like to speak on. And so I tended to focus on small business. And one of the first things I tried to help resolve was some of the banking scandals where big banks had mistreated small businesses, particularly Lloyds HBOS and RBS GRG. And so I spent many years on the all-party group for fair business banking on those particular issues. And then...
Just slow down a little bit. You mentioned, I think, the APPG.
That's right.
Just tell us very shortly about that APPG.
Yeah, sorry, APPG is an all-party parliamentary group on fair business banking, which was there to try and make sure that small businesses had a voice when they were mistreated by large organisations. And there was some terrible mistreatment of small businesses by those particular banks. And so when I came across this particular scandal, which I did as a result of a letter from Paul Marshall, who's one of the barristers who got involved in this case and sought to have injustices brought to light, and did so successfully. I met with him and I realised how serious this was, but also the parallels that existed between this scandal and previous scandals, where we'd sought to get compensation for those people. And so it then became something I talked about from the backbenches and continued to do so until I was appointed minister. And that's why I said it was something that I was very pleased that was part of my portfolio, because as a backbencher you have influence, but you don't have any power. But even as a junior minister, you have some power to try and make things happen, and that's what I tried to do as the minister.
Thank you. Can I look at an example of what you did from the backbenches? Can we look, please, at UKGI 3030648? It'll come up on the screen. And if we look at the foot of the page, we'll see an email from you to Darren Jones and others on the 5th of July 2020. This would have been at the time that you were a backbencher.
That's correct, yeah.
And if we look at the bottom of page 2, and on to page 3, we can just hit signed off by you as MP for Thurston Moulton and the co-chair of the APPG that you've just mentioned.
That's right.
And we see that this was primarily addressed to Darren Jones. If we go back up to the, thank you, the distribution list. Can you help us at this time? In what capacity or context were you writing to Darren Jones, July 2020?
Well, it was trying to highlight some deficiencies with the compensation scheme primarily.
Sorry, it's my fault for a poor question. In what capacity were you writing to him?
Yes, Darren Jones is the chair of the Select Committee, the Business and Trade, Business, Energy and Industrial Strategy Select Committee, as was then.
Thank you. And so he was the committee chair with he was chair of the committee with primary responsibility for essentially the business area of the post office and its scandal. Exactly
right. And he was doing some work, the committee was doing work on the scandal, and it would be, as I said before, as a backbencher you don't have the power, so you need to draw together a coalition of people to try and raise issues through various different channels, and this is one of the channels we were trying to use to raise issues we felt existed with compensation schemes.
Thank you. And you say thank you for the fine work that you and the Select Committee are doing with regard to the post office scandal. You may be aware of the above issue already, and by that I think you mean the subject line, another post office scandal, convicted claimants paid no compensation by the post office. Is that right?
That's right.
But I've been contacted by Paul Marshall, a barrister who has been informally assisting some of the post office victims about a further injustice relating to this scandal, in that convicted claimants have been paid no compensation by the Post Office and are specifically excluded from the historic shortfall scheme. Paul originally contacted me as a result of my work of the chair of the APPG on fair business banking on the Lloyds HBOS Reading scandal, where he highlighted clear parallels between this affair and the similarly disgraceful abuse of power in the Post Office scandal. And just to note, we've got those documents that have kindly been provided, with Mr. Marshall contacting you on 2 occasions and drawing parallels between the Lloyds HBOS scandals and this one. That someone should be prosecuted by a state institution and imprisoned on the basis of false evidence known to be false is antithetical to everything that liberal democracy and the rule of law stand for. I should just say that the purpose of me asking you questions about this is to gauge the temperature of your feelings whilst a backbench MP, and see whether you carried those forwards when you became a minister.
Sure.
Such things are rightly associated with authoritarian and despotic regimes, and yet for 20 years the Post Office conducted such prosecutions. Over the page, you then give some examples. Tracy Felstead was imprisoned aged 19 in 2002. Mrs. Seema Misra was imprisoned when 8 weeks pregnant in 2010. Their cases have been referred to the Court of Appeal by the CCRC, together with 47 others, following Sir Peter Fraser's judgments in the Post Office litigation, Bates versus Post Office litigation. Post Office Fujitsu witnesses have been referred to the DPP. The CCRC has described these prosecutions as, quote, an affront to the public conscience. It's now emerged that while many assume that the Post Office paid about £58 million, the vast majority of which went to pay costs and expenses in compensation to its sub-postmasters and mistresses, including those who have been convicted and imprisoned as a result of its seriously flawed prosecutions, this assumption is correct. Astonishingly, it's now apparent that under the terms of the settlement negotiated between Freeth, the 550 claimants, and Herbert Smith, Freehills for the Post Office, it was agreed the Post Office was to pay no compensation at all to claimants in the Post Office litigation who had been convicted of criminal offences. The explanation for this remarkable conclusion is provided by a note written by Paul, a copy of which is attached to this email. And you indeed attached a copy of that note to the email. Putting to one side any legal justification for that extraordinary outcome, none being immediately obvious, it is one that will offend anyone with a sense of justice. Many of those convicted and imprisoned, perhaps understandably, have suffered serious ill health, including mental illness as a consequence. I'm also very concerned about the involvement of Herbert Smith Freehills. I'm not going to read that paragraph, but essentially you say that you fear that they've adopted an overtly and overly adversarial approach. You say, I urge the Select Committee to lead the calls for a proper compensation scheme that will enable all the victims of this terrible tragedy and injustice to receive reparation for the injury done to them by the Post Office, that is, shorn of niceties, a state institution. The continuing absence of such a scheme will augment injustice with injustice and be inexcusable. It's an outrage that some victims should now be left to their own devices to pursue an uncertain claim against the Post Office for malicious prosecution. Further, the circumstances of the settlement, denial of recompense to those most grievously injured by the Post Office, now adds to the requirement for a proper public inquiry into this shameful episode. At the very least, the time period for the HSS should be extended by 3 months to the 14th of October 2020. This will provide a reasonable opportunity for those affected to be able to properly evaluate the courses open to them. The issues demand careful and mature consideration. And then you say you copied in the Business Secretary, Alok Sharma, the Small Business Minister, Paul Scully, and the Justice Secretary, Robert Buckland, who clearly have an interest, and I hope will also take up these matters. You expressed, I think it's fair to say, very strong opinions on this scandal in the course of this email, didn't you?
I did.
Did you carry those very strong opinions into government when you became a minister 2 years later?
Yes, I did.
And it's apparent from the evidence that we've got that you tried to resolve what might be described as issues with compensation and redress.
Yes, certainly tried to do that.
What hindered you?
I think the nature of any compensation scheme, and I saw it in the previous compensation schemes we had dealt with at Lloyds, HBOS and RBS, is that any compensation of any individual is complicated. Because everybody's life is different, everybody's lives are complex, and the detriment to people's lives is often completely unique. Of course, it's completely unique. So if you're going to set about putting in place a compensation scheme that's going to assess everybody's loss individually, that's going to take time. And it's a bureaucratic process. You need to do.
Sorry to interrupt you. So essentially, the first part of your answer there was, it's the nature of the exercise. So it's not somebody hindering me or an institution hindering progress. You're saying it's a natural consequence of the problem that needs to be solved.
I never experienced anybody, the question is, I never experienced anybody in government or the civil service who tried to hinder compensation to any individual. It's a result of a complex process that inevitably is the case between an individual whose life has been affected in many, many different ways, both in terms of financially, in terms of their health, their mental health, their physical health, that of their families, that in terms of the impacts upon their livelihood. All those things have to be taken into account. And I think one of the things we need to learn from this, and I've covered this in my statement in later stages, is how we do this better if this, God forbid, this should ever happen again. And so I think so when you have said in your earlier remarks on this is that, you know, in terms of the compensation schemes, you know, if you're going to go there, you wouldn't start from here in terms of how we've done this. But nevertheless, we are where we find ourselves. And so it's the complexity is the biggest problem, and the adversarial nature of putting a claimant's lawyer arguing the case with the department or the post office's lawyers, and that doesn't help either. And so there are ways, I believe, to expedite that, some of which we found through things like fixed sum awards, which have had a great deal of success, but there are other things we need to do as well to try and expedite this process now and for future compensation schemes.
In the course of that answer, you said that you didn't come across anyone in government, and you included with that the civil service, who hindered you. Did you deliberately exclude the post office?
No, I didn't. I mean, I don't believe anybody in the post office sought to prevent compensation flowing. And again, that's something I've covered in my witness statement. I think there were some failures within post office, you know, some of the disclosure failures which have been well publicised for the inquiry, but also in individual cases took too long and were flawed, and the mistakes were made. So, so there are logistical problems, and some of that has to be described as incompetence as well as failure for other reasons. But I don't think I didn't met anybody who didn't want to compensate postmasters as quickly as possible.
Thank you. Can we look, please, at Bayes 301023? This is an email exchange from, in fact, earlier this year. You'll see that it's dated the 5th of February 2024. And it's from Minister Hollinrake, that email address, to Rob Brightwell, who's a civil servant in the department, along with Carl Cresswell, who we're to hear from later today, and others. And if you look at the foot of the page, please, and over to the next page, you'll see that it's from Jamie Lucas, who was, I think, then your Deputy Head of Office and Private Secretary. Is that right?
That's right. If
we go back to page 1, please. It refers to a slightly impromptu meeting with the Minister, i.e. you, just now. And it's apparent that a submission has gone up to you, and you've provided comments, and he's passing these on to the civil servants. Yes?
That's right.
And you comment essentially in 5 bullet points. You say, I'd like to see how we calculated Alan Bates's compensation, please. Even a ready reckoner of £50,000 a year for 18 years plus interest seems to be considerably in excess of the offer we made. Not sure we aren't making all this too complicated, getting into the weeds too much at times. The £450,000 interim on receipt of a full claim is a good idea. We should do the same for the GLO, say £50,000. Why does it take 30 weeks to respond to a late HSS claim? I think we need an appeal mechanism in addition to the HSS FSA. I think we should consult the HCAB, the advisory board, before implementing either. Please can I have a table showing a comparison of tariffs for non-pecuniary overturned convictions versus HSS schemes. I think that's essentially what you're describing in that last bullet point.
That's right.
And so the passages in italics there, that's essentially you speaking directly.
Yes.
And so what you would have read a submission, not liked some of what you had seen in it, and passed this on to your private secretary.
That's right.
Did you do this frequently, this kind of thing, get actually into the details of individual claims?
Yeah, where necessary. I mean, obviously, ministers are not there to resolve individual claims, but I was concerned, I think, as anybody, when you felt things were not working as quickly as they should. And the the bureaucratic nature of things, as I say, I expressed some frustration within those paragraphs about, just really arguing about very small elements of a claim, which, speaking frankly, and listen, this isn't a criticism of lawyers, so I hope you don't think it is. There's a lot of lawyers in this room right now. I don't want to do that, but it can be the case that things take too long and for the wrong reasons. So arguing about the mileage claim for somebody going, which I heard of one claim, just somebody's had to prove their mileage going from the place of home to the place of work while they were waiting for their compensation, is not the kind of thing we should be doing. I just felt there wasn't a sense check about, when I dug down in some of the claims, I would do. I didn't. I think at times we have to get into the weeds as ministers myself. We can't just rely on everything we are told. And so it would be the case that people would contact me through various different sources, could be email or social media, and I would be willing to go in and say, okay, tell me about that case and tell me why it's taking so long and tell me why the offer is at that level when it doesn't sound like anywhere near the level it should be. And I think I expressed that frustration in Sir Alan Bates's case, in that, it was the level of offer that I established that had been made didn't seem to make sense when you took a common sense view of it.
Your private secretary continues, skipping over the next line. He, that's you, has also expressed to me that he'd like the detail behind a number of high-profile claims. For example, Jo Hamilton claims that her original offer went from 20% of her original claim to 80%. Why is that? Christopher Heads was only 15% of what he claimed. Why? And obviously, as referenced above, Alan Bates's claim. There's a note already being drafted on this. Your private secretary understood. And so one can understand why that you would wish to know the detail of what you described here as high-profile cases, because you might be asked about them. Was that the reason that you were getting into the weeds here? Of course, that's we're public servants. We react to public concern, quite rightly, but it was more about how the schemes were operating. Were they operating effectively? Were they operating on a basis of common sense? Were they operating on a basis that the benefit of the doubt was given to the claimant? All the things we had committed to do, and I would expect a compensation scheme to operate on that basis. So it was really trying to not resolve that particular claim to get it out of the newspapers. It was a case of, let's improve these schemes across the board, and so these were just examples of things I was aware of. I took the same view on things that didn't
weren't necessarily as high profile as Sir Alan Bates or Joe Hamilton. It was on people that I say contacted me directly. I would try and get the same answers in those cases.
And so is this kind of thing that we read here typical of you essentially carrying forward the rather strong sentiments that we saw expressed in your backbencher MP for when you went into office as a minister?
Yes, that's exactly right.
Thank you. That can come down.
Attention please, attention please. This is the test of the fire and voice alarm system. There is no need to take any action.
Mr. Hollinrake, I think we can continue now. We're about to turn to a new topic, which is post office governance and the provision of information to you from or by the post office and decision making. If we can start by looking at your witness statement, please. It will come up on the screen, page 6. Paragraphs 19 and 20.
Before I do that, can I just add to what I was going to say earlier?
Absolutely.
It was probably caught a little bit by the fire alarm. I suppose what I felt through this, having been through what I saw in the Lloyds compensation scheme, that the legal system, for whatever reason, I'm not sufficiently qualified to opine on it, but treats people when they are mistreated terribly, especially big companies and the individual. And yet, when it comes to the compensation, the people who are responsible for the compensation, I felt, treat those people, hide behind the law in terms of properly compensating those individuals. And I think there's something fundamentally wrong with that. And this isn't the only time we did it. You know, the fact in the Lloyds scheme, we handed the compensation back to Lloyds to provide the compensation. And the fact in the HSS scheme, we handed the compensation scheme back to the post office to deliver the compensation. I think, A, that doesn't give anybody confidence that the compensation will be delivered properly, but also then it becomes very legalistic. And I think there's something very fundamental we need to learn from that. Some of that was covered under the National Audit Office report on this, but we should never do it like this again.
Can I ask you 2 questions arising from that answer? You said that when providing compensation for those that have been wronged, we tend to, quote, hide behind the law. That tends to suggest that you've taken the view that those that are providing compensation or determining compensation are not applying the law as they would see it.
I don't think that. I don't think it was, they're not applying. I think they're applying the law too strictly. In that this is how we compensate people according to the principles of how a court would deal with this. And this is how we arrive at the calculation that we would, through a very complex assessment of loss. But I think to me, that is too much. We need too legalistic, too adversarial, and it doesn't give the benefit of the doubt to the claimant, and it becomes very, very bureaucratic, and there are some basic principles of how you compensate people through the courts. I understand that, but I think applying purely legal principles to this, I'm sure there are very good reasons why that happens, but does mean that these compensation schemes, to me, can be flawed.
Can I explore that part of the answer a little further? Is your view or your complaint that the law is used, i.e. the common law and statute law, in determining the amount of compensation, or is it that lawyers are involved in the administration of the scheme?
Yeah, I think it's a bit of both, but if two lawyers are arguing, that can take some time. And again, I'm outnumbered in this room, so I'm not trying to be critical of the legal processes. But to me, there should be, as the National Audit Office said, and one of the things we tried to do and probably failed to do. I made mistakes here. I'm not saying I was the only person who did anything positive in this space, not at all. Many good things were done by many people, both the Ministerial and through the civil service through this process. But I think there is that you need somebody independent of the legal processes, sat in the middle somewhere, to be able to sense check some of these things that are happening, rather than applying the strict rules of engagement, the rules of compensation in these situations, because that will just take too long and not properly reflect the situation that people have faced or the losses that they have incurred.
The second follow-up was that you said in your first answer after the fire alarm that we handed back or handed to Lloyds and then the Post Office responsibility for administering the scheme, or in our case, some of the scheme. What's your, can you develop, please, your complaint or view there?
Well, the culture of the Post Office has been discussed at length. So people are bound to feel there is some of that remaining within, in terms of the claimants, and I think that probably some of that was remaining. I think, but there's going to be little confidence from a claimant when they feel they're being compensated by the organisation that's been responsible for the huge suffering that they've experienced, that they're going to get properly compensated, and that suffering has been properly recognised. So I just don't think that's the right way to do it.
Was it an active question within your 18 months as a minister, under consideration of whether the Post Office should be given or should retain responsibility for administration of any of the schemes?
So yes, certainly. And again, I know. So when you've stated this in the past, in terms of, we are where we find ourselves. So revisiting the HSS scheme, which had largely, by that point in time, made offers to the vast majority of people who had put claims in, starting that all again, although we did, as you referred to in some of my earlier comments on this, is that we should put in place an appeal mechanism, so people who feel they've been shortchanged could contest the compensation they've been provided with, and latterly, we also pushed for a fixed sum awards for those people, so compensation could be topped up to at least a minimum level. So yes, it's very much the case that I felt that shouldn't have been given to the Post Office originally, but it was. On later schemes, the GLO scheme was given was as in agreement with the claimants' lawyers, was done by DBT, operated by DBT, which I think was much better. I'm not saying even then you shouldn't do something slightly different than that in the future. But one thing that I was surprised about early on in my tenure as minister, I think this decision might have already been made, but the overturned conviction scheme was then given back to the Post Office to handle, which again to me, was a step backwards from understanding the GLO scheme should be handled by the EBT, so independent of the Post Office. Then the first overturned conviction scheme was handled back by the Post Office, and that, to me, is the wrong thing to do.
Was it ever passed on to you that Mr. Reid, as CEO, and his board corporately did not wish for the Post Office to administer either the HSS or the GLO scheme?
I think the Post Office, including Nick Reid, would have been very happy if they weren't dealing with the compensation. That was certainly the conversations I had with Nick in the past.
And so why was it, if there was a meeting of minds between you and him, that didn't happen? Because
the decision had already been taken. The HSS had already been largely, like I said, most claims had been either resolved or offers had been made. The GLO we decided to do externally, which I think everybody was happy with. And the the overturned conviction schemes, the original one, although it came across my desk, I remember making some comments on a brief that I'd had that I don't understand why this is going back to the Post Office, but I think a decision had already been taken by the Secretary of State at that point to do it that way.
The Secretary of State at that time being?
I think the original decision had probably been made by Kwasi Kwarteng. I can't be sure of that, but certainly it was a comment I made to on the brief I received, that I didn't understand why this was going back to the Post Office.
Thank you. Can we then turn to the topic I was
going
to? No.
Before we do, Mr. Beard, yes. I understand your concern about each side arming themselves with lawyers and arguing it out. I don't think I am a lawyer anymore, I can say that. I used to be one, but I'm not anymore. Anyway, but it was both the Post Office's choice and the department's choice to arm themselves with lawyers. They didn't have to have a room full of lawyers to argue this out. That was, if I can use the word, your choice.
Yeah.
You were collectively, you understand.
Yeah, that's right.
So why?
Well, as I say, I don't think we should do that in the future. I think we should have some independence set in the middle of it, and something that I certainly...
I appreciate about the future, but, and I'm absolutely not saying this in a critical sense, it's an inquiring sense. You obviously had considerable scepticism about how quickly lawyers could sort this out.
Mm.
So you become the relevant minister in 2022. Admittedly, HSS is well down the road, but the overturned convictions scheme wasn't well down the road, and the GLO scheme had hardly begun, right? So why not then say, right, we'll have a completely different attitude in the Post Office and the department. We won't arm our defence with lawyers. We'll have reasonable whoever who'll just look at these claims and make fair assessments.
Yeah. And if I had my time again, that's exactly what I've done. One of the mistakes I made. It was very early on in my time as Minister that the GLO scheme came down the track. It was only after 2 or 3 months after, I think, and met with various different people, including people like Kevin Jones, Loda Buthnut and others, who were all seemed to be quite happy where the scheme was established. Now, looking back now, I don't think I should have been happy with that. I think there were scheme reviewers. Sir Ross Cranston was brought in as a scheme reviewer for the GLO. I think what I should have insisted on at that point in time was for someone like Sir Ross to play a greater role right at the start, rather than being the backstop for disputes. And I probably hoped, which is probably a vain hope, that process could happen more quickly. But it's too far down the line. So I hold my hands up. I'm going to say sorry to people whose claims have not been settled quickly enough through that process. It's something I got wrong. I'm sorry that's the case.
Well, I wasn't actually, as I hope I made clear, necessarily saying you were wrong, but I was exploring the reasons why, in the end, this scheme, all schemes, have become these are my words and they may not turn out to be my final words, but apparently a battle between lawyers in certain cases.
It's definitely the case, and something we should not let happen again.
Can we then turn to the topic, topic 2? It was paragraphs 19 and 20 of this witness statement, and this is after you become the minister. You say, I continue to be briefed on issues throughout my time as a minister. I have regular meetings with the lead departmental officials, David Bickerton, Director General, Carl Cresswell, Director, Rob Brightwell, Deputy Director. And in those meetings, I'd often make requests for more information on particular topics and raise and discuss ideas for change. And then in 20, you say, it was also important to me that I should receive unfiltered information from stakeholders. And right from the start, I asked my private office to arrange calls with Nick Reed, Alan Bates, and Lord Arbuthnot. And so you're there describing getting information through the usual channels, i.e. through departmental officials, but also going directly to both the post office and to relevant stakeholders, yes?
Yep, that's right.
In your witness statement, it's paragraph 55, which is on page 14. Just by way of background, in 54, you say the government and post office have approached compensation with the best of intentions. There'd obviously been a number of problems, especially in relation to the pace at which sub-postmasters have received compensation or not. And then you set out some reasons, and you say there were, as I understand it, a number of reasons for this during my time as minister. And then the first of those is slow and flawed disclosure at the post office, by the post office. Can you help us? What information were you provided with as to the post office providing slow and flawed disclosure in connection with the compensation schemes?
It wasn't information I was given by officials. It was just usually case when I've spoken to victims, when of the representative of victims, or evidence we'd hear at the select committee inquiry, or things I would read in the various media reports. So that's tended to be where it would be revealed that was taking longer than it should.
And so this is disclosure by the post office in and for the purpose of a compensation and redress scheme?
Yes, absolutely. I'd speak to, obviously, the claimant's lawyers, and they would say to me, that's certainly part of the problem. I think that was a problem particularly early on, when the Post Office, to be fair, was getting up to speed with a lot of these cases. As we introduced things like the fixed sum awards, which are one of the things that have made a big difference in terms of making sure the flow of compensation increased. And there has been, I think, around a fourfold increase in the amount of compensation paid over the last 12 months. I think now it stands at £438 million. It was just over £100 million this time last year. So many things have worked that we tried to do. But so one of the areas that helped in was the Post Office. By using that approach, it meant the Post Office had fewer cases to have to disclose evidence to, because the fixed sum awards don't require disclosure of evidence. So there is a twofold benefit from using that approach as one way to get compensation to people.
Other than the introduction of fixed sum awards, did you do anything in response to the information that you were given that the Post Office was providing slow and flawed disclosure?
Well, certainly it was a topic of conversation we had when I had regular meetings with Nick Reed and others, that we urged them to increase the pace of compensation. We were always reassured that was going to be the case. Again, on an individual case level, if things were brought to me, I would attempt to have those cases, understand why those cases were taking so long, and urge the relevant participants to accelerate the whatever information gathering was needed and provision was needed. We also set an SLA service level agreement kind of expectation on things like the GLO, that offers were made to individuals within 40 days of offers being of claims being submitted, but of course that's down the track from when claims could be submitted because they would require the disclosure of evidence to make the claim. So there were some attempts to accelerate things, but we also brought in scheme reviewers, again, Sir Ross Cranston being on the GLO scheme, Sir Anthony Higginbottom on the overturned conviction schemes, which we were very keen to make sure that they could play some part in trying to make sure those schemes were fit for purpose. And indeed, the establishment of the Horizon Compensation Advisory Board with Lord Arbuthnot and Kevin Jones, and I was very keen to make sure there was cross-party representation on that, but also there were people who had been fierce critics of the government on that board, including Professor Richard Moorhead, to make sure that they could have some oversight of how those schemes are operating and establish where things are going wrong and be able to advise us on what we need to do to try and help.
You also cite, as a second reason, this is something you've mentioned earlier this morning, the fact that large claims were being held up by demands for detailed information on trivial issues, such as mileage travelled. Who was providing you with that information?
It would tend to be the claimants. I think this is something that Jo Hamilton, for example, has often mentioned to me, and when I've met her, there was information required that seemed pretty trivial and not material to what compensation might be offered, that would seem to be have to form part of the claim before it was submitted.
And in relation to that, did you communicate any concerns about delays in large claims being essentially stalled by demands for trivial details to anyone at the Post Office?
So yes, certainly. That's a conversation we had in our regular meetings with the Compensation Advisory Board, how we do this a different way. It was very much the case that that I felt that there should be some sense checking rather than simply this going getting sense checking in terms of what might be an appropriate level of compensation for those kind of things, and there would be and that there should be a way to give an assessment of somebody's loss without having to go into a detailed assessment of that loss. There should be, and this is something that was piloted, that there should be a general less of an expectation, less requirement for there to be a submission of individual loss at a financial level or in terms of people's health or mental health, that we should be able to work that on a basis of some kind of tariff. That was certainly a scheme that was piloted within the department that I understood helped to some degree.
You also cite, thirdly, the requirement that each claim had to be supported by medical evidence of trauma and physical impacts and forensic accountancy evidence for financial loss when these experts had limited capacity. And who was providing you with that information?
Again, that was a conversation I had with the civil servants, Cal Cresswell, Rob Brightwell, who were clear that there were some issues around just, there was a queue for getting the forensic accountancy or the assessment of somebody's impacts on their health, on their mental health, and those kind of things can take time, even when the people are working on those cases, but there's a queue of cases to be heard by those people who are experts in that field. If we could move, and I think we did this on a pilot basis, which I understood was successful, this was probably towards the end of my tenure as Minister, to have, say, a general kind of a low requirement for assessment of individual need and more of a kind of general figure that could be put on that kind of loss that could provide a basis of compensation rather than a more detailed assessment.
You've mentioned a couple of times in your answers that you asked for the issue that was being raised in front of you to be sense-checked, or words to that effect. What did you mean by that? I sometimes find that when people use that phrase, it can carry a number of meanings, some of which obscure what's in fact happening.
Well, I mean, I think I used that initially in terms of Alan Bates' case. You know, if you just look at the case, somebody's been campaigning for on behalf of, you know, thousands of people for 20 years, and then you make an offer of compensation at the level it was initially made. You just think somebody's been working for 18, 20 years on a case. You know, the amount of time it would require for somebody to work on that full time, and I'm sure he's working more than full time in his campaign. You can probably add it up pretty quickly that claim should be significantly higher than the claim was initially issued. And similarly with things like Joe Hamilton.
Stopping there, you mean sense check in apply some common sense? Yeah,
that's exactly what I mean.
Okay. You were moving on to Joe Hamilton.
Yeah, well, similarly, you know, asking Joe to evidence her mileage between her home and her workplace, where she had to clean to keep to make sure she could pay for the things she needs to pay for and subsist, was just to me ludicrous.
There were proposals, thank you, that can come down, for upfront offers in a fixed sum. Where did that idea originate from?
It originated from me. I floated the idea at a departmental meeting with the Secretary of State and the Permanent Secretary and Dave Bickerton and others were at that meeting, and it was a frustration from myself and the Secretary of State, indeed, who was always very supportive of all my efforts to accelerate compensation, that things weren't moving quickly enough. And to be honest, again, I wish I'd recommended it earlier, because it was very well received by all the people at that meeting, that we should look at a different way of doing this. But the original idea came from an idea, you know, a principle, an approach we took at the Lloyd's HBOS compensation scheme, where we suffered exactly the same problems, even when the scheme was redone with Sir David Foskett as running the Foskett panel. Still, the compensation claims took a long time to assess those losses and to agree what the compensation level should be. So what we alighted upon was using this fixed sum award approach, which was very successful, and allows people to walk away from the process much more quickly and get compensation much more quickly and move on with their lives. Because as we know, and it's terrible to hear about Mrs. Riddell, and my thoughts are with her and her husband and others, how people have passed away without ever seeing compensation. It's simply wrong. And it's a way we can accelerate the compensation to make sure those people at least can move on with their lives to some extent after what's the terrible things that have happened to them.
Can we look, please, at Bayes 40808? This is a letter. I think we've only got this as an undated, or finally dated draft, but it's dated August 2023. You'll see that it's from the Secretary of State, who was then Kemi Badenoch, if we just go to the top. Thank you. To the Chancellor, then Jeremy Hunt. Accelerating Post Office Compensation is the title, and Ms. Badenoch's letter reads, Kevin Hollinrake and I are both determined that postmasters affected by the Post Office Horizon scandal should get proper compensation. They should get it as rapidly as possible. 3 compensation arrangements are at different stages of maturity, and then you summarise, including some she summarises, including some figures, the HSS, the overturned conviction scheme, and the GLO scheme. Ms. Badenoch continues, the scandal ruined many postmasters' lives. The longer compensation goes unpaid, the more criticism we shall face, including from the Williams inquiry, if we were to fail to compensate all the GLO members in time, we would face severe criticism from all sides. Kevin and I have therefore been looking at ways in which we could rapidly speed up the processes. We already make interim payments of £163,000 to almost all postmasters whose convictions are overturned, and we undertake only limited scrutiny of GLO claims for certain heads of loss under £10,000 and HSS ones under £8,000. We are looking to extend these measures substantially in relation to the GLO, which has started to receive claims. And then over the page. Some of the options we're considering would actually save more on the cost of lawyers or other advisors than they would cost in extra compensation. Others do have additional costs, but in my view, these would be well worthwhile in the light of the non-financial benefits of accelerating the schemes. In particular, I'd like us to be able to offer a £100,000 fixed payment to every claimant who applies to the GLO scheme. I recognise that announcing this would create significant pressure to offer the same for HSS claimants, which we should consider separately, but I believe this is the right route forward for the GLO scheme. Such radical action would offer great advantages in terms of the speed of the process. The Departmental Accounting Officer has expressed some concerns about the value for money given the repercussive risk and raised the potential need for a direction for this idea. That's a reference to a ministerial direction, yes? I would welcome your views on the best approach, being mindful of value for money considerations, whether you agree we should pursue this. And the letter was copied to you. So this was a joint suggestion between you and Kemi Badenoch. Is that right?
That's right.
Do you agree with everything that she's written?
Yes.
Can we look, please, at Bayes 40705? We can see from this, if we go back down to the bottom, please. So it's over the page, the end of the letter. Mr. Hunt, the then Chancellor, replied, and go back to the top. We can see in his paragraph 1, in his reply to the Secretary of State, Ms. Badenoch, that her letter must have been dated the 9th of August. And then if we scroll past paragraphs 2, 3 and 4, he addresses the request, the ask, in relation to the specific proposal for fixed sum awards on the GLO scheme. While successful delivery is paramount, we must also have regard to our responsibility for the public finances and to ensuring that the treatment of claimants on each Horizon compensation scheme is fair to that of their peers. As you note, making fixed sum awards on the GLO would incur significant repercussive risk and costs, including to the HSS. Given the extent of this risk and its high likelihood of crystallisation, I'd encourage you to explore the full breadth of other options to advance the ultimate objective of timely and successful delivery of full and fair compensation. And then the letter continues about some other things. That's essentially a rejection of the proposal. Is that right?
Yes, that's right.
It doesn't say so. It in as many terms. It says please explore other options.
Yes, clearly we were.
What was your reaction to the rejection of the proposal made by you and Ms. Badenoch?
Well, disappointment, but I wasn't surprised because it was quite a. I think the Secretary of State had described the proposal as radical, actually, in a previous letter, and it is quite a radical thing to do. And a permanent secretary would never sign this off on value for money grounds because that's what permanent secretaries are there to do, to protect public money. Personally, I felt it was still the right thing to do, and we continue to press for it because I think Jeremy Hunt has always been massively supportive of everything I tried to do in terms of providing compensation to postmasters, as has the Secretary of State and others, and the Prime Minister, indeed, Rishi Sunak. But I don't think any of them had the experiences of previous compensation schemes that we had experienced, the ones I referred to earlier, particularly Lloyds and RBS. So I felt it was something we would in the end have to do.
Thank you. Can we move to Bays 40722? And can we look, please, at the bottom of page 2 and on to the top of page 3? You can see an email from Carl Cresswell to, amongst others, your email address. It's Minister Hollinrake. The rest of it has been redacted on data protection grounds. Is that essentially your private office?
Yes, that's right.
It wouldn't be to you personally?
No.
And this is essentially a record of the outfall from the decision that we've just looked at. We can see that it's in late September, September the 22nd. And if we go forwards to point 3, so if we just scroll down, please. Thank you. On 3, that's a reference to a point earlier in the email chain, which I'm not going to turn up. The CST, which I think means Chief Secretary to the Treasury, is that right?
That's right.
The Chief Secretary to the Treasury, that would have been, I think, John Glenn at that time, is that right?
I think it was, that's right.
That was before Laura Trott took over in November. The Chief Secretary to the Treasury has approved in principle a higher scrutiny threshold for group litigation order claimants. He has tasked his officials with agreeing a sensible level with us rather than picking a figure such as £100,000 or £50,000. Our current scrutiny policy is rather selective and just covers up to £10,000 shortfalls. So moving to a higher and less restrictive threshold as soon as possible would be useful and enable us to process more claims more quickly. Can you explain to us what the higher scrutiny threshold means?
It would mean when you did receive a claim, whatever that scrutiny threshold was, if it was below that threshold, then there would be a pretty light touch process in agreeing the claim. So if it's £10,000, what you expect to say it's less than £10,000, just pay it. And what the officials were keen to do, and I was keen to do, was raise that threshold. So if you got a claim up to, say, £100,000, that light touch process would be applied to that particular claim. So you wouldn't get into this lawyer-to-lawyer process of arguing about semantics, I would say, in many cases, about the level of the claim in certain areas. You just pay it.
And so by raising the level, you would bring more claims within the no or lesser scrutiny
That's right.
approach.
Yes. I think it's fair to say probably this is one of the alternatives to a fixed sum award. The difficulty with this in replacing a fixed sum award is that clearly you can't reveal this scrutiny threshold to the claimants, because everybody would just put a claim in if it was lower than that up to the £100,000 level, let's say, if that's where you set the threshold. So it's something you use internally rather than disclose externally.
The email continues. This leaves the question of our proposed upfront offer of £100,000, which the Chancellor is resisting on the basis of concerns about precedent for other compensation schemes, as well as potential repercussions. As we explained ahead of the recent Secretary of State meeting, we floated the idea of a £75,000 upfront payment with Treasury officials, but were again rebuffed as a matter of Treasury principle. Our understanding is that the Chief Secretary to the Treasury is sympathetic to our proposals from a political perspective, but feels unable to go further because of advice from Treasury officials about the impact on other compensation schemes, e.g. infected blood, and the strong views of the Chancellor. I'd be grateful for Minister's views on handling, please. So that's a direct request to you, is that right?
Yes.
In addition to reaching agreement at official level to an amended scrutiny threshold, even a level of £40,000 would enable us to process a significant number of GLO cases more rapidly. Minister Hollinrake, Secretary of State, could consider writing to Treasury ministers to represent the case to them and ask them again to reconsider. I prefer not to hold up progressing the scrutiny threshold because we're processing cases every week and it may take a while for that political conversation to reach a conclusion. I'm reading between the lines here. Can you help whether I'm correct in my reading between the lines? That there was a difference of view between the Chief Secretary of the Treasury and the Chancellor, and you were being asked as a minister to approach the Chief Secretary to the Treasury, i.e. at ministerial level, rather than going back to the Chancellor, who had expressed his view more than once.
I might be wrong, but I don't think the Chancellor and the CST did differ, actually. I think the CST was happy to look at, Chief Secretary of the Treasury was happy to look at higher level of scrutiny, but still had the same reservations about the fixed sum award, the upfront offer, as he calls it here, as the Chancellor did on value for money grounds. And I know this has been a topic of conversation, and you've queried it, I think, Sir Wyn, in terms of public money. There is a requirement within the work we do and within the civil service to protect public money and to look after public money. And it may seem callous in this regard, and I can understand why people might see it like that, but you've got responsibility to the individuals, their families, of course, to properly compensate them. You've also got to be fair there. You've also got to be fair to other postmasters, so everybody gets treated equally, but you've got to be fair to taxpayers as well. And so I do understand the grounds whereby ministers and officials would push back against the fixed sum award, because it does mean extra levels of compensation. It does mean more money paid out. So I don't think anybody pushed back on the higher scrutiny level, although they did ask us to decide upon or argue for what the right level. But the fixed sum award was more difficult to agree. It is quite radical. My experience was that civil servants, certainly Carl Cresswell and Rob Brightwell, were very supportive of that, as was Dave Bickerton and the Secretary of State indeed. But when he gets to permanent secretary level, both in the Treasury and in DBT, Department of Business and Trade, at that point in time, somebody has to sign it off with value for money grounds. They would not do that. It would have to be ministerial direction, which I was very happy to sign if somebody asked me to do that, but I can understand why it's controversial.
Could you have been the appropriate person to have signed a ministerial direction?
I don't think without the support of the Secretary of State, realistically, or indeed the Chancellor, that would have been possible.
Do you think the Treasury regarded the Post Office scandal as the priority that you evidently did?
Yes, I do, although I probably had greater experience of it than some, perhaps, of the people working in the Treasury. So I think anybody who's had the direct experience by predecessor ministers or civil servants dealing in these cases, or many of the backbench members of Parliament, or many of the campaigners, obviously, here and further afield, knew how serious it was. I don't think until the TV series was aired that that was a view widely held everywhere in government and everywhere in the public consciousness.
What was your response to the Treasury's resistance to the proposals that were being made to it?
We'll keep making the case, as we did one-to-one conversations with various ministers in Treasury. I perfectly understood the response because of the reasons I set out earlier about public money. But I still think it was the right thing to do, so we kept arguing for it. But in the meantime, I think, as Carl says in this email, he says that we'll carry on with things we could do. In the meantime, things like the scrutiny threshold, which would help, while we'll still continue to make the case for fixed sum awards, as we'd got agreement to do in the overturned convictions. What this is really talking about is expanding fixed sum awards into the GLO and the HSS, as eventually we did.
Can we look, please, just before the break, at poll 0044 8411?
Can I start before we go to that? Actually,
absolutely.
Just the reference there to the infected blood. One thing, and this is obviously not a matter for this inquiry, Sir Wyn, but to me, the infected blood scandal should have fixed sum awards. And that's not a feature of that compensation schemes right now.
Can we go to...
I think I've got my hands full without that.
Understand that.
Thank you. This is a letter with which the inquiry is familiar. It's from some anonymous post office whistleblowers. I think you've seen this as a result of disclosure to you in the inquiry. Did you see this at the time?
Not at the time. This was about a week after the election was called, so that kind of correspondence would not be shared with me. It may not be shared with me in normal course of events, because I think this letter is unsigned, actually. So
yeah, it isn't signed. It's signed off by the poll whistleblowers. We can look at that at the foot of page 2. Yeah,
it's signed off on unnamed people, which I've got to say, in my experience as a member of Parliament, and I think people who are not prepared to put their name to a letter, I think you're bound to think twice about completely trusting the contents of something that's not signed by an individual.
Could you think the opposite, that the strength of views that expressed are to be accorded particular weight because the people who are writing the whistleblowing letter think that retribution will be taken against them if they are identified?
I think it's something you should read. I don't think you wouldn't read it, but I think it's, if somebody makes allegations that they're not prepared to stand up to the individual, I understand why somebody might not want to, particularly if they hold a position that might be affected by the claims they make. So I'm not saying you shouldn't read it or ask questions on the basis of it, but I think to trust it completely on the basis it's not something you can then go and interrogate both sides. Clearly you can ask questions of the people who allegations are made against, but it's difficult. Obviously you can't then go and ask questions of the people who have made the allegations.
Thank you. It's just one passage in paragraph 4 on page 1. The paragraph beginning, furthermore, it says key people are not being appropriately managed by, that's Nick Reed or Mr. Reed. You are no doubt aware that Ben Fote has been given significant time off work. He's hardly been seen this year. And for the last few months, he's been on permitted fully paid leave to allow him to prepare for his half day at the inquiry on Monday, the 3rd of June. Not only this, but he's also had a forensic lawyer assigned to him for over 12 months to assist with the questioning at the inquiry, costing the public, we're told, about £700,000. We're all wondering why on earth he has to practice so hard to tell the truth. And then it continues. Were you aware of this suggestion that one of the witnesses to the inquiry had had a lawyer supplied to them, which would cost about £700,000?
I wasn't aware of that figure. I mean, it doesn't surprise me that they had legal advice. I had legal advice to give evidence today to understand the process and what was expected of me. I was very surprised that anybody needed time off to be able to prepare for this inquiry. I've never had any time off to prepare for it.
But I think you're saying that because of the timing of this letter of 20th of May, it was within the PERDA period and therefore it wouldn't have got through to you.
Yes, I never saw this letter at the time. I only saw it, but it was given to me as part of the bundle.
And so it wasn't something, because on the one hand, you're campaigning quite hard for fair provision of full and fair compensation to sub-postmasters. And on the other, on the face of it, a relatively high sum of money is being expended for preparation to give a half day's evidence at the inquiry. But this didn't essentially arrive in your inbox.
I don't know if it's true, but it seems an absolutely ludicrous amount of money if that's the case.
But it didn't get through to you.
No, I never saw this letter until I saw it.
And so you couldn't have caused it to be investigated or explored.
No.
Thank you. So might that be an appropriate moment
Yes.
for the morning break? Can we break until 11:05, please? Well, I think it's remarkable. Thank you, sir. Mr. Hollinrake, can we just continue on the issue of compensation a little longer and go back to paragraph 55 of your witness statement, which is on page 14. Thank you. You mention in B and C essentially evidential thresholds for claiming and then the payment of compensation, yes?
That's right.
Are you aware that UKGI was involved in setting the minimum evidential thresholds?
No, I wasn't aware of that.
Were you under the impression that these were threshold? Well, who did you think set the minimum evidential thresholds?
Well, I guess I assume they were set by DBT, whoever established the terms of compensation that would form the basis of how the compensation processes would work. So I expected it would be the department in consultation with legal representatives.
Would you agree that medical records are necessary for those claims which allege some personal injury, whether physical or psychiatric, so that the severity of the injury can be accurately assessed?
I think that was definitely the principles of the scheme. I think what we tried to do later on is reduce the need for evidence around that. So you might say, well, somebody in these circumstances, we would expect the compensation for somebody in that circumstance, whatever happens to them, to be at this level, and rather than the need for specific assessment of that, the impact on that individual. That's what we're trying to get to reduce the need for this evidential requirement. But to form a basis of somebody's claim, I think that I understand why that was part of the original scheme. Because every situation is different, therefore it's difficult to assess everybody's loss or impact on somebody on the basis of a tariff. But what we looked at doing later on, as I said earlier in my evidence, is maybe there's a way to do that without the need specifically for that to be evidenced. If a claimant's lawyer could say, well, this is the impact we believe based upon other experience we've had with other claimants, this should be the level of compensation for the impact they've had on their lives, and then hopefully that could be then agreed without needing for detailed assessment, which should accelerate the process of compensation.
And presumably you would be aware that in some cases obtaining medical evidence can benefit claimants by achieving a higher award, or, for example, where the expert recommends that treatment is necessary, then that treatment, the cost of that treatment can be part of the claim. Yeah,
and nobody would ever want to stand in the way of what any assessment that would lead to fair compensation of an individual's claim. It wasn't saying there would be a cap, it was simply saying, is there a way to expedite this on the basis you could have a sum that might reflect the impact on that individual that could be agreed between would be it the claimant side, claimant's representatives and the representatives on the other side of the scheme, be it DBT or Post Office.
As to D, the involvement of lawyers on all sides, is it your view that postmasters should have the assistance of a lawyer for complex claims?
Oh, yes.
Are you aware that the department has rejected a suggestion that early legal advice, i.e. pre-offer for postmasters, should be funded by Post Office?
I think that the different schemes operate in different ways. The HSS operated on a different way. I think the legal advice came down the line rather than up front. So, which, you know, I think the idea behind the HSS scheme, as I understand it, was to try and take away some of that lawyer-to-lawyer friction and to try and make these claims, try and expedite the claims to make them be able to settle more quickly. I understand why that was done like that, but that may well have meant that people didn't get the right advice early on, which is one of the reasons we wanted to push for fixed sum awards on the HSS scheme, because there was a concern that things like consequential loss weren't properly assessed in the original scheme.
Are you aware that in most cases, the majority of cases in the HSS, they do not involve lawyers or forensic accountants' evidence?
I think I understood that to be the case, yes. It was supposed to be assessed in a non-adversarial process. So the panel of cases and other experts were there to try and take an inquisitorial approach to assessment of the compensation and pay it that way. It was, as I say, an attempt to take away some of that lawyer-to-lawyer friction. But there may be concerns then raised that did people get the right advice right at the start?
And then finally on this, are you aware that for cases outside the parameters of the funding agreement between DBT and Post Office, the Post Office is required to wait for settlement offers to be ratified by the department, who then have on occasions to liaise with the Treasury?
I wasn't aware specifically of that process, no.
Can we turn, please, to the issue of the relationship, that can come down, thank you very much, the relationship of postmaster non-executive directors to the board and with government. In a witness statement provided to the inquiry, there's no need to display it. The reference is WITN 11170-100 at pages 109 to 110. Saf Ismail, one of the postmaster Neds, said that he, quote, had conversations with individuals at DBT, namely Carl Creswell, and the minister, to raise concerns that the business of the Post Office was in a very precarious position, but that he felt ignored. Firstly, do you remember Mr. Elliott coming to you?
I remember we had a meeting, an online meeting with Saf Ismail and Elliot Jacobs, I think, to discuss where the Post Office was and their role within it in terms of being non-executive roles and the potential change of chair. And of course, I can't think specifically. I can't remember specifically them saying that that things. I don't remember them saying everything is fine. Nor can I ever remember them saying that things were disastrous and unfixable. And certainly, my feeling was in that conversation that we had with them online in that meeting was that they were both very keen on the new chair we were recommending to take over at the Post Office, Nigel Relton.
Can we look, please, at Bayes 301020? You'll see this is an email from and to your private office email address, yes?
Yes.
And this is, as we've seen in the past, a means sometimes employed of recording a meeting, an email to yourself, essentially.
That's right.
In this case, it was from Jamie Lucas again to himself. Essentially a minute of the meeting. Is this the meeting you were referring to?
That's right.
It's the 28th of March this year. And you'll see that it records in a sort of semi-verbatim fashion what was said, with you being referred to as Kevin, Mr. Jacobs as Elliot, and Mr. Ismail as Saf. You'll see there's some quite general information passed, and essentially sort of pleasantries right at the beginning, where I think you were presumably warming each other up at the beginning of the meeting there. And then if we look at the second paragraph, you say we're on the same page on central costs. And Mr. Elliott says the minimum wage is becoming a problem. Bottom of the page, you say agree with what you said, the top and the bottom of it. This is essentially about not horizon issues at the moment here, speaking about essentially the future of the post office. And then over the page, they say that it's a lack of the roadmap that's a problem. We live in, I think that's supposed to be a never-never land between sustainable business and social purpose. You ask who your standout is. Mr. Jacobs replies, Nigel Relton. Mr. Elliott, Mr. Ismail agrees. And then it continues. What was the purpose of your engagement with the Postmaster Neds in this way?
I guess to find out what was going on at the sharp end and what they really felt about the business. And I was keen to have their confidence that we were truly interested in making sure that the post office had a viable future, not just as a network, but also at an individual postmaster level. So I always like to talk to the people who are at the sharp end, and I think both Saf and Elliot are both operators as well as non-execs, so they are postmasters as well as non-execs. That's the reason they're on the board. So very key to hear from their perspective, but also for them to feel that they were being heard.
Was this part of a regular series of meetings with them, or was this essentially a one-off?
I think it was a one-off, although I had spoken to them in separate situations when I attended a board meeting, and I think when we were at various conferences, National Federation, the sub-postmaster conferences as well. So it was never something I was afraid to do, talking to the people who were the operators of the network themselves.
In general, what was your relationship like with the two Postmaster Neds?
I think good. I say it wasn't a day-to-day working relationship, but I hope they felt that I was willing to listen to what they had to say, and the responses I gave them were what I truly felt. And as it says in this exchange, I did agree with a lot of the things they were talking about, particularly the need to reduce central costs so that more of the revenue that flowed into the post office centre then flowed out to the postmasters who are actually doing the day-to-day business at the sharp end.
Do you understand how Mr. Ismail feels able to say that he felt ignored after his conversation with you?
I would surprise that's the case, but if that's how he feels, that's how he feels.
Did you take any action as a result of the things that they said to you in the course of the meeting?
Well, I think the principal thing we were talking about here, which is what we certainly agreed on, was the need to cut costs at the centre, which is something that I was very keen to do. That was something I'd talked to Nick Reid about and other members of the Post Office Board. I got frustrated. I think I said in my witness statement that didn't happen more quickly. But that was certainly a conversation I had with Nigel Railton when we first met about the potential for him to take over as chair. And I understand, you know, Nigel was always very keen to do the same. He felt the same, and I think he's spoken subsequently or recently about his plans to reduce the costs at the centre, which definitely need doing. So I don't think there's anything in here fundamentally, if we're talking about central costs or the shape and size of the network, which are both are matters for consideration and action, or anything that I didn't agree with or wasn't willing to act upon. So I'm surprised he felt ignored. I'd be very happy to have a conversation about why he felt that.
Thank you. That can come down. Turning then to the issue of cutting central costs, can you firstly explain in summary terms what you mean by cutting central costs?
Well, it's not, I had a business background, and when you hit trouble in a business, and as the network has, and lots of those troubles have come as a result of customer behaviour, as well as other matters in terms of how difficult it is as a postmaster to make a living. So you know, we use high street shops less than we did before because people have different ways of shopping. I understand that, and so the post office and lots of the services we used to get from post offices, such as our driving licence or passport, many of us do online now, which has hit postmaster income significantly. So what you do when you're in a situation where your branches are less profitable, the first thing you should look to do, in my experience, is cut costs at the centre, because they are not the most important people in your network are the people who are serving the customers day to day, because they're generating the revenue. So what we'd expect to happen, therefore, is the size at the centre, particularly the executive and the management team. You look at how many people you have in that executive management team, and you look to cut it. And typically what I did at my own business, when we hit trouble in the past, you would have cut that by at least 40%, if not more. And that's some of the conversations we had with the chief exec and their team, and the finance director, the acting finance director, the acting CFO. You know, how many people were at different salary levels within the organisation, and what was going to be the direction of travel in terms of reducing the costs of those people at the centre. There are other costs as well, and the plans to reduce costs of directly managed branches, for example, which are a significant cost, and to Post Office Limited, and that was something we discussed. But certainly focusing on the people, the management team at the centre and the executive team. I think 143 people and £100,000 or more, and you expect there to be a direction of travel in terms of reducing the numbers of people who earn that kind of money.
Can we turn, please, to page 8 and paragraph 30 of your witness statement? Under the heading Post Office Board and Culture, within paragraph 30, you say this: there are also signs that the Post Office remains too inward-looking and dysfunctional. And then examples of being too inward-looking and dysfunctional you then give. You say good examples are the failures to disclose information to the inquiry, 2, the slow pace of disclosure for compensation cases, 3, the reluctance to reduce central costs to allow a consequential increase of revenue to postmasters, 4, the Henry Staunton saga, 5, the failure to deal with long-standing issues with senior executives, such as Alistair Cameron, 6, the Remuneration Committee's decision and processes around the sign-off of bonuses for complying with the inquiry's disclosure requests, 7, the persistent and aggressive lobbying by the CEO to significantly increase his remuneration. It's quite the list.
Yeah.
Amongst those matters that you mention is a reluctance to reduce central costs to allow a consequential increase of revenue to postmasters' remuneration. The way that's written, I take two things from it. Can you tell me whether I'm correct to do so? Firstly, that you drew a link between the reduction of central costs and the increase of revenue to postmasters.
Well, inevitably there is.
Was that the purpose of the reduction in your mind of central costs?
Yes, of course.
And then the second thing is there was a reluctance to do so by the,
Yes.
by the post office.
Absolutely.
Who within the post office did you detect a reluctance in to reduce central costs?
Well, the chief executive. I mean, the chief executive carries the can for everything, and it's not easy to be a chief executive, and it's not easy to be a chief executive of an organisation that had hit so much trouble. So I sympathise about the difficulties of running this organisation, but that I don't sympathise with doing things that were clearly needed to be done. And had Nick Reid come back to me and said, "No, you're wrong, Minister, Kevin, what you want to call me, we need to keep those people for this, that and the other reason," then I would have listened to the argument, of course, but I never heard a compelling reason why that should not be the case. There was, as I understood it, acceptance that this should be an area where we'd look to save costs. That could mean then more money flowed into the postmasters themselves. But then nothing happened about it, despite our urging at every juncture, into every meeting, and you could easily say, well, you should have done more, and I would hold my hands up and say, I should have done more to insist upon this, but that was never properly forthcoming. And that, to me, is a failure of leadership.
Can I look at those two things that I've taken from the sentence and that you've confirmed then? The first of them is the link between a reduction in central costs and increased remuneration for sub-postmasters, and that as an aim, by looking at poll 0044 7841. You'll see this is a letter from you to the then chairman, Mr. Staunton, of the 29th of June 2023. It's a 5.5 page letter, including its annex, and its heading sets out its purpose, namely to set out the strategic priorities for 2023 to 2024. Could you just explain why you write letters of this kind and what their purpose is?
Well, obviously, we are the shareholder for the organisation, and therefore it's sort of to us to set out the priorities that then the chair and the chief exec should then focus upon.
Page 2, please. You say, I would like you to focus on the following priorities and align the reward package to the shareholder priorities. So align the reward package to the shareholder priorities. What does that mean?
Well, I would guess that's a case of the any bonuses that would be due to senior executives should reflect the priorities that's set by the shareholder.
Okay. 1, effective financial management and performance, including management of legal costs to ensure medium-term viability. For the financial year 23 to 24, the Post Office should, and then as the 4th bullet point, maintain stringent cost control and maintain a clear focus on value for money and efficient delivery across the cost base, including, and then there are 5 sub-bullet points, the last of which is other measures aimed at reducing central costs wherever possible. So is this the record, essentially, of you telling the Post Office to reduce central costs?
Yeah, I mean, that's one of the records. Other records are contained within the meetings that were minuted between myself and Nick Reid.
But this is a particularly formal way of doing it,
yes,
by setting out the shareholders' strategic priorities. Is that right?
Yes.
This says that the direction to reduce central costs has as its aim the medium-term viability of the Post Office. Yes?
Yes.
In the heading
That's
at the
right,
top.
it says, yeah.
rather than with a view to increasing postmaster remuneration. And in the letter, it doesn't set out as a strategic objective the need to increase postmaster remuneration, or that the Post Office should work towards that. Was that a strategic priority?
Well, yes, it definitely was. It wasn't a case I was trying to do this to reduce the contribution by the taxpayer. It was a case of, from my focus, it was very much all the conversations I had with postmasters, be it through the conferences I attended or by other means, was very much an understanding that life was difficult as a postmaster. Many were working at or below minimum wage, and the post office itself would not be viable if its network would not be viable. So that's the most important part in terms of viability of the network, in my view.
And if we just look through, if we scan through the 4 strategic priorities, there's a mention at the foot of that page there in the last bullet point under number 2 of postmasters, but that's in the context of rolling out to them the strategic platform modernisation programme. So far as I can see, that's the only mention of postmasters in the strategic priorities. If we go over the page and look at priorities 3 and 4. Are you saying that it was to be taken as read that postmaster viability and as part of that remuneration increase was a strategic objective?
Well, I don't think anybody who had an interaction with me in terms of the management team or leadership team would have any doubt that it was my intention and a requirement of their work to make sure that we reduce costs, to make sure that the beneficiaries of that should be the postmasters. It may not specifically say this in here, and maybe it should have done, but that was certainly the case. That's what we were intending to do.
Could I look at, thank you, the next part of the equation then in that sentence that we read, which was that there was a reluctance within the Post Office to reduce central cost. By looking at Bayes 40805. And I think this is essentially a presentation or a series of slides for a presentation for a meeting that was held in December the 5th, 2023, which I think you attended. Yeah. And this is part of the Post Office presentation to you, or to the meeting at which you were present. And it's, I think, annotated up the slide pack, if we look, for example, at page 3, presumably by somebody at the department, because this was disclosed to us by the department. Overall, can you just describe the purpose of the meeting? Can you remember?
Well, obviously, central cost is mentioned there, and one of the, I think, the next slide then talks about the number of people on high salaries. So I'm not saying the only purpose of the meeting was to look at central costs, but as far as I was concerned, that was one of the most important areas for discussion at the meeting.
Can we turn to page 7, please? Further scope for self-help is possible, but this either involves trade-offs in the near term or it delivers benefits outside the 3-year plan. And this is the Post Office speaking, essentially. We have cost savings targets for the financial year 23 to 24. I think that's a reference back to the letter that we just looked at. And we'll have further targets for 24 to 25. And then, however, cash constraints limit what we can deliver in the near term. If the department was to do something, and noting the substance has been flat for 5 years, we would have to do something. We would have more funds to support cost-saving activity. We know our costs can and should be reduced, and we have a track record of taking costs out across our business over the last 10 years. But to have any material lasting impact, we need access to funding. With limited capacity, tight cash and uncertain future funding, working up detailed cost saving plans is speculative and high risks. Plans developed today can only be implemented today. Is this, was this Post Office saying to you that cash constraints limited how far the Post Office could cut its central costs further than it was already doing without government support?
Yes, that's right. That's what they're saying.
Do you agree that government constraints, in fact, significantly limited how far Post Office was able to go in cutting central costs?
No, I don't. And I've had the conversation, I think it's been minuted elsewhere, that whenever we discuss this, there are things like directly managed branches, for example, redundancies at the centre. All these things cost money. In the short term, there's a short-term impact when you make these decisions. I completely understand that. My clear message to Nick Reed and others was you make the business case for that investment that we would need to get from Treasury to make those, to fund those changes, and I'll make the case for you to make those changes. So there should be nothing that would stop Nick Reed or others making the business case to me, and if it made sense, I would have taken that to Treasury to get the money if that made financial sense to do so.
So is this what you were being told on this occasion evidence of or an example of the reluctance to reduce central costs that you've described?
Well, it was one of the barriers that might put us in the way. The response I always get to that is, fine, OK, we'll come back with a business plan to do that. I never got that business plan back. So there was never a clear argument made to me to say, OK, you put X amount of money in here, we can deliver that, we can bring that money back to you in savings or in terms of how that may work over a period of time. And so that was never the case it was never the case that case was made. I've heard this a lot from a business perspective, how that you need people at the centre to do all the work at the outside, and even though the outside is getting smaller, and clearly in many ways the branch network is getting smaller because some of those branches are not physical branches anymore, they're drop and collects and other things, yet the centre remains the same size. And to me that's wrong, that's a wrong emphasis. The first thing you should do is look to reduce costs at the centre, but it's not uncommon that the management team at the centre don't want to do that because there are lots of people they work with on a daily basis. So it's a difficult thing to make redundancies. I've been through it. It is heartbreaking. You are letting people go you work with for a long time, but that doesn't mean that's not the right decision to make. And but the difficulty here was it just did not move forward at the pace it should have done.
You tell us in your witness statement that the solution is good leadership. Nothing can replace that. It's paragraph 48.
Yes, I said that.
Would you accept that as the government minister for this 18-month period, you had a role in the leadership of the Post Office?
Yeah, of course. And you could easily make the argument I failed, I should have pushed harder. I will hold my hands up to that effect. The thing is, you can't do it for them. The chief exec there for a reason paid a lot of money to do that job. The chair the same. And the other members of the management team, you can see how many people in this organisation. There are 43 people, I think, in the organisation paid more than £150,000 a year. So you'd expect those people to be competent at delivering on priorities set by the shareholder.
You say this of Mr. Staunton, if we turn it up, please. It's page 9 in your witness statement. at 34, which is at the bottom. Whilst I did not have regular contact with Henry Staunton, as Nick Reed was my principal point of contact at Post Office, my own view of Mr. Staunton was that he was incapable of chairing this organisation. I first started to doubt his judgment only a few days into my ministerial role, when he strongly advocated a very large percentage increase in the CEO's remuneration. I was very aware from my meetings with senior officials at UKGI, Tom Cooper, and then Laura Grattan, that they did not rate him very highly and felt he was a chair from a previous generation. Given that you had doubts about Mr. Staunton as soon as you took office and heard from others about his inadequacies, why did it take a considerable period of time after then to essentially move against him and ensure his removal?
I don't believe you should go around sacking people on a whim. You know, I always try to work with people in my business life and also in this life in trying to give people the opportunity to get the job right. Now, that was an early reflection in terms of the remuneration point. It wasn't handled directly by me. It was my Secretary of State, Grant Shapps, who handled the remuneration situation. So, but certainly a chair coming along and arguing for, I think I've never seen the letter, but I think it was a doubling of Nick Reed's salary. I think we all were pretty shocked by that within the department. So at that point in time, red flags appeared, and I think it wasn't the only time he made that case. But you know, I say it wasn't my principal point of contact as we went through this, and certainly it was only latterly we heard that Mr. Staunton's allegations, I think proven allegations of misogyny and racism and bullying, these kind of things that he was alleged to have done. You know, over time it became the case that I think it was quite clear his position was untenable, and that was a position that was held by UKGI and the civil servants responsible.
Why did the senior officials at UKGI not rate Mr. Staunton very highly, so far as you understood?
I just don't think they felt he chaired the board very well. I think if you look at the report that was done separately evidenced by Grant Thornton, talks about some of the processes, meeting discipline, lack of structured management information, all those things a chair is responsible for. So I guess that was a reflection of some of those failures at board level, and that's very much the responsibility of the chair.
In paragraph 36 of your witness statement, you say you're aware of Mr. Staunton's allegations in which he claimed that a senior departmental official had told him to go slow on compensation for sub-postmasters, and also about the reasons he was given for his departure. And you say, so far as I'm concerned, this was nonsense. Can you explain why you think that what Mr. Staunton has alleged was nonsense?
Well, I just don't imagine who we had a conversation with on that basis. And if you look at Mr. Staunton's evidence to the Select Committee, after he was let go, he actually says there's nothing wrong with the HSS schemes. I think that's, again, evidence within my witness statement, that he said that bit of it was going fine. Now, I think anybody who's been through this process as part of HSS would not say everything was fine with the HSS schemes. We know there were problems with that. In fact, he refers to that in one of his other emails about this claimant who received £16,000. That's one of the concerns he raised. So I just do not think that Mr. Staunton's evidence holds water on so many different levels. I think what I think he says in the Select Committee, the problem was with the overturning of the convictions, which we did. We overturned the convictions of probably 700 people, but that was something we were in the process of doing at that point in time, something that never happened in the history of Parliament. So I just didn't think that any of his allegations were ever evidence or ever made sense.
Thank you. Can I turn to Mr. Reid? You tell us in your witness statement that the Post Office was your number one priority as Minister, that you spent at least 25% of your overall time and in many periods a much higher percentage focused on the Post Office, and that Mr. Reid was your principal point of contact at the Post Office. You tell us in paragraph 44, if we move on, please. Thank you. As time went on, I formed the view that Nick Reid was unable to lead the organisation as it needed to be led. And you say, I repeatedly asked for basic information about management headcount and a plan to reduce senior management headcount and costs. It was like drawing teeth. What information are you referring to? Basic information?
Well, you saw, I think, earlier on, the it's in evidence in the pack, if it wasn't shown on the screen, the numbers of people earning more than £100,000. You'd expect, quite simply, the situation today, and this is what I set out at various meetings we had, how did you think those numbers, what the direction of travel of those numbers in a year's time? In 3 years' time, you expect that direction of travel to be significant in terms of reduction of cost. It's quite simple. You'd expect a chief exec to deliver that from one board meeting to the next, so within a month, and that never happened.
You tell us in paragraph 46 that you work constructively with Mr. Reid, you would meet and talk. You thought it might give him a decent chance to see through the reform of Post Office's culture, but my view was that the guy was being paid lots whilst not doing a very good job. And on the other hand, sub-postmasters were struggling to break even at best. But what, in your view, were the key issues with Mr. Reid's leadership at the Post Office?
Well, I was always been told that things within the Post Office, Nick Reid was having problems doing and motivating the team. I think I was told by Lorna at UKGI that the team needed motivated. We need to bring somebody else in to motivate the team, the leadership team. Well, that's the job of the CEO, quite clearly, reducing central costs, the disclosure of information, to the inquiry and to make sure that information was disclosed to cases. I think there was at one point a server was discovered, or two servers were discovered that carried lots of information that hadn't been disclosed to the inquiry. There were constantly a number of different issues that were being raised with me and that all being raised in the media that gave rise to concern that the organisation wasn't being led well. I think, again, this is set out by the Granthorne report in terms of the limited effectiveness of the board, as it was stated in their report of June 24. A lack of clarity, low levels of trust within the board, no unifying purpose, a lack of succession planning, and we talked before about the processes of meeting discipline and the people agenda. So it was quite clear that the organisation was not being run as well as it should. As I said before, it was a difficult organisation to run, hugely in the public spotlight because of all what's happened to it. So I'm not saying this job was easy, but I think there were some fundamental failings and shortcomings amongst the leadership that meant it hasn't moved forward at the pace it should have done.
Paragraph 45, which is above the one highlighted, you say Nick Reid's pay as CEO was always a running theme. I'm not going to explore that with you. But later in the paragraph at the end, you say it was generally thought that Nick Reid was always on flight watch, even before this. First of all, can you explain, so that I understand, what you mean by he was always on flight watch?
Yeah, I think Henry Staunton had referred to this, and so had my officials at times, that he may leave if he wasn't given more pay. So not just that. That's not the only thing that Nick might consider is a reason to leave. You know, he was massive under pressure, and I think anybody running that organisation would have been. So I understand this was not an easy gig, but I think principally it meant he'd leave if we weren't careful. My response always to that was, well, you know, if that's the case, that's the case, and we'll find somebody else to lead the organisation if he decides to leave.
You tell us later in your witness statement that, quote, my own view was that we should not be moved by the threats to leave. If he wanted to leave, he should leave. Is that right?
That's right.
Can we look, please, at poll 0044-8706? This is a letter from you of April the 21st, 2023, about Mr. Reid's remuneration to Mr. Staunton, the then chair of the Post Office. And you say in the second paragraph, the government continues to be grateful for Nick Reid's work in leading Post Office. Since his appointment of Chief Executive Officer in September 19, I recognise the significant commitment and effort he's putting in to tackle the multiple challenges that the company is facing. If you just scan the next two paragraphs. And then the large paragraph at the foot of the page. And so this, you refer to a miscommunication between Post Office and government in relation to a backdated pay increase for Mr. Reid. You say that you were content to approve it and that you recognise the significant commitment and effort he's putting in to tackle multiple challenges. Can you help us? Why did you approve the backdated pay increase if Mr. Reid wasn't, as you say now, doing a very good job?
Well, this is fairly early on, don't forget. I mean, I think I was moved from the machinery government changes, I think, came into effect in February of that year. So my responsibility for this at that point in time was greater. I think my previous Secretary of State held a lot of the responsibility with the Post Office prior to that. My new Secretary of State, Camille Badenoch, had been very happy to lead me more to it since then. As a general principle, I'll work with anybody until I'm ready to not work with that person. So it's not the case of, at this point in time, we were trying to bring about Nick Reid's departure. It was the fact if he was ready to go, he should go. But we won't say at this point in time we should, you know, it's something we were actively trying to do in trying to get rid of Nick Reid. So in that being the case, we would try and work with him on a basis of a constructive relationship. And Nick Reid at this point hadn't had an increase in pairs. I think it says in the letter since 2019. And there was this confusion about when this pay rise was made. And you know, this is a context of some much larger pay rises that Nick Reid and the chair was pushing for. It seemed a reasonable thing to pay this relatively modest increase in his pay at this point in time on the basis he hadn't had a pay rise for 4 years.
Mr. Hollinrake, thank you very much. Those are the questions that I ask of you. Thank you very much for answering them. There will be some questions from the core participant representatives. Sorry. There'll be some questions from the core participant representatives, taking us up to about 12:30. So I think we start with Ms. Page. We've got questions from Mr. Steve as well, and one from Ms Watt on behalf of the NFSP.
Mr. Hollinrake, hello.
Hello.
I want to ask some questions about the £600,000 offer which was made to those whose prosecutions were held to be an affront to the public conscience. In January of this year, Mr. Ricaldin from the Post Office's compensation schemes had an exchange with the Department for Business and Trade. He started it off with Carl Cresswell and Rob Brightwell. They remained copied in throughout the exchange, but the responses came from Beth White. And if I can just summarise what he says in his emails, his argument was that the £600,000 was effectively a flaw in the sense that everyone in the overturned conviction schemes would be entitled to it, and therefore it should be paid to everyone straight away. His point was that those who were able to show that they were entitled to more could treat it as an interim payment, and for everybody else it would just be a full and final payment, but paid out straight away. And his argument was also that paying it out to everyone straight away in that fashion would get compensation flowing quickly, because everyone's entitled to it, everyone might as well have it. Those who still have more to claim thereafter can do so in the time that takes. Do you see his point?
I do.
Well, the response that he received was as follows. I think we will have time to bring it up, so I'll ask for it to be brought up. It's Bayes 400738. And if we could start on page 2. If we could zip down to page 2, thank you. Simon, this is Beth White, and as I said, it's copied to Carl Cresswell, Rob Brightwell. Simon, you asked yesterday whether the aim was to get money as quickly to claimants or to get F&F, evidently full and final shorthand, or to get F&F settlements to claimants. Our focus is on achieving the latter. This proposal, i.e. his proposal, doesn't encourage any pace or movement to full and final settlements, does it? Ministers and politicians, as shown in the Select Committee, are keen to take steps to encourage victims getting their full and final settlement as quickly as possible. And then if we go up, he tries one more time, and then on page 1, Miss White comes back to him again. He says, so we hold back funds that we could pay to pressurise, quotes, encourage F&F. And then her response above that. And if I pick it up from the second sentence, you asked yesterday whether you should focus on maximising payments or maximising settlements yesterday. We were very clear that we would like you to focus on ensuring that claimants are able to settle their claims as quickly as possible, as this is what ministers and other politicians are keen to achieve. Neither Mr. Cresswell nor Mr. Brightwell stepped in to contradict that. Was the Department for Business and Trade right to say that ministers wanted to effect full and final settlements ahead of getting payments out of the door?
So just ask that question again.
Well, these responses are saying very plainly, we don't want you to maximise getting payments out the door. We want you to maximise getting full and final settlements. That's right. What we're aiming for.
Okay. No, that we wanted both. Will you go back to the original point that Beth made?
Yes.
Where you said
2.
in that first sentence.
You asked.
Okay. Yes, that's right. So you asked whether the aim was to get money as quickly to claimants or to get full and final settlements to claimants. She says the focus is the latter. I say the focus is on both. Because the way the fixed sum award works, as you will, I'm sure, know, is that some people, if they'd gone through a full and final settlement, would have got less than £600,000. Some would get more. So the point is, it shortens the queue for the others. If you take half the people out of the queue, because one of the problems we heard is getting people heard, that their claim heard, or getting the assessments made, forensic accountants, experts on mental health and physical health, all those things. But if you have fewer people having to go through that process, they can get to the claim point more quickly because people have come out of the process. It was never trying to say to somebody, your claim might be worth £1 million, we're going to give you £600,000 to get you out of this. It was a choice people could have, and they could make the assessment based upon their personal circumstances. It was never trying to shortchange people.
Well, let's have a look at how it panned out as far as Mr. Ricaldon was concerned. In the inquiry on Monday, he said this: I was extremely uncomfortable with that, and I think I'm making my point, articulating of what is the right thing to do, because I didn't want to delay. It seemed to me I was getting an implication to delay redress in order to hold out for full and final settlement. There's an offer there. I want to pay the offer amount, i.e. the £600,000. Then I don't want to feel restricted about not paying that out because I'm only going to pay out if it's a full and final settlement. But they made it clear, absolutely crystal clear, no, Simon, the objective is there, black and white, full and final settlement. So I then had to issue instructions internally to say that those potential interim payments, the government will not approve them now. And they didn't approve them, because they were holding out for full and final settlement.
He's wrong. And if he'd come to me and expressed those views, I'd have explained to him why he's right. I'd listened to him. We had this very similar conversation with the Horizon Compensation Advisory Board. And a lot of Button made this argument too. He said, well, why can't we just pay it to everybody and then we'll let the people want to claim more? And you can make that argument, and James did. But I said, I'd point to it, if you do that, you will not shorten the queue for people who think their claims are worth more than £600,000. So I pointed out before how we've seen this massive uplift in compensation over the last year, which has got to be a good thing, a fourfold increase to now over £438 million, I think it is. A lot of that is through the fixed sum awards. I think of the latest scheme, of the GLO scheme, of the 306 claims submitted so far, 96% have received offers, 295, 228 have agreed offers, I think 66% of claims through the fixed sum awards. Again, in terms of the new Horizon Convictions Redress scheme, 36 claims have been submitted, 36 offers have been made and paid. So we're seeing much more rapid compensation through this mechanism. That does not stop people going for the full assessment. And if you complete a full claim, which you can do more quickly now because you can get access to the reports now for the forensic accountants and the other advisors you need, as soon as you've submitted that claim, then you get £450,000 as an interim payment.
Why not 600?
Why not 600? Well, it was actually £450,000 as recommended by Sir Gary Hickinbottom as the payment we should make. I can't remember why we said not £600,000 at that time. I guess it because the claim might not stack up at £600,000.
Is it not because it's putting pressure on people to accept the full sum of £600,000?
That was never the intention.
It might not have been the intention. Can you not see that that's the effect?
Well, if I'm very happy to hear from you or anybody else in this room or anybody else outside this room about ways to accelerate compensation to individuals. We felt this was the best way. I'm very happy to have a conversation with you at a later stage why you think, how we think we might do this in a better way, and the advisory board would do that too. But we accepted virtually every recommendation made by the advisory board. Our intention was always to try and expedite claims, full and final settlement or full assessment claim on the fixed sum award, whichever people would prefer.
But this was the message that your department sent to the post office. You asked yesterday whether the aim was to get money as quickly to claimants or to get F&F settlements to claimants. Our focus is on achieving the latter.
Well, that's not true. And I never had a conversation with Beth about that, if she'd asked me how to explain it to her. But definitely myself and Carl Cresswell and Rob Brightwell and the Horizon Compensation Advisory Board were all completely on the same page as this is the right way to do it.
One more issue, if I may, Mr. Hollinrake. It's about Herbert Smith Freehills. Now, in January of this year, Post Office told you that HSF were to be phased out. In March of this year, in another meeting, I can give the reference because this is not one that's come up before, we don't need to look at it, Bays 400754, you were told again that the Post Office were looking at alternative providers. Back in July of 2020, in the email that you wrote as chair of the APPG, which we've already looked at, you said on page 2, I'm also very concerned at the involvement of Herbert Smith Freehills, who I understand are advising on the design and implementation of the historic shortfall scheme. The mere fact that HSF acted on behalf of the Post Office in the legal action with the responsibility to minimise losses should prohibit them from taking any role in a compensation scheme. And of course, you were also aware, and you said in that email, of their involvement in the compensation scheme for small businesses after the banking scandals. And the question marks over their role in that case as well. It was an obvious problem, wasn't it, having Herbert Smith Freehills involved in the compensation schemes? And yet here they were 4 years on, and you were still having warm words about them being phased out, alternative providers. Do you regret not doing more to make sure that they were properly exercised from all the compensation schemes?
Yes, absolutely. I mean, you know, I'm sure some very good people in Herbert Smith Freehills. I'm not criticising everybody who works in that organisation, and I'm not saying they weren't trying to do the right thing, but perception is reality. I mean, I think there's a certain part of, as has been said earlier, within this inquiry and by the chair, that we are where we find ourselves, and what's the best way from getting here to there. So, yes, I mean, just tearing out a big lump of the existing compensation scheme and the processes and the legal advice to that scheme maybe isn't the quickest way to get compensation out the door. So it does take longer. Should it have happened in the first place? Absolutely no, it shouldn't.
Thank you. Those are my questions.
Mr. Hollinrake, my name is Sam Steen. I represent a large group of sub-postmasters, also people that worked in post office branches, and we represent people that have been through the Court of Appeal and who have had their convictions overturned, and people that have had their convictions overturned via the legislation. Now, you've mentioned and discussed with the Chair, Sir Wynne, the issue of lawyers being involved and how far and to what extent that assists. You've had experience yourself, am I right in thinking, with a constituent of yours who came to you to discuss their issue, someone that's been affected by the post office scandal, and that they were discussing with you an NDA, non-disclosure agreement, and the potential effect of their signing of the Official Secrets Act. Is that right?
I don't remember that particular case. I did have a constituent in Norton, near Helmsley, who passed away, but I'd never met that individual before what was the case, so who'd been as part of the 555. I may be wrong, but I don't honestly think I did. I think David Davis brought up the point in Parliament about the Official Secrets Act and the implications that had in terms of the ability for people to speak out.
I'm grateful that's of assistance. Sub-postmasters signed the Official Secrets Act on taking up post. As far as I know, they still do so. I'll stand corrected if I'm wrong. And one of the issues that we have come across is that they therefore think that may inhibit them actually engaging with the Post Office, even on such matters as compensation schemes. So that's something that's been raised. We can't go into parliamentary discussions, but that's something you're aware of that's been raised.
Yes, I'm aware of that.
And we have experience as well that since the legislation cleared those people who had not had their cases taken before the Court of Appeal before, because there's a certain issue regarding people that have gone to the Court of Appeal in the past. but those people in the past whose convictions have been cleared. We've had people contacting my instructing solicitors, Howe & Co, saying, we've got this letter about my conviction. Is it real? Is this the post office trying to do something else? In other words, the sheer level of mistrust that is engendered by scandals such as the post office also means that people need support from lawyers. Do you agree?
Oh, yes. It wasn't a personal criticism of you, Mr. Steen, in terms of my earlier remarks on lawyers.
Thank you very much. And I'll put that one on my website. The other issue, of course, and perhaps slightly more seriously, is that people that have been through these scandals, the post office scandal, you mentioned the blood inquiry and what happened there, people are damaged, severely damaged. People are damaged in their physical health. People are damaged in their day-to-day ability to cope. People's lives are blighted by lack of sleep, mental health problems, and the like, by the fact that they are forced into poverty, by the fact that they are forced into trying to cater for the day-to-day. Now, you're someone with a long track record of supporting small businesses, and you know that small businesses depend upon everybody working together to run that business within a family, yes?
That's right.
So again, the difficulty for those people left in these dreadful situations is that they do need support from lawyers that are prepared to engage at early stages with either government or what's happened within a scandal in order to provide access way to compensation, yes?
Quite right, yeah.
Right. Let's go one step further. The route through which compensation is often argued tends to go this way before inquiries. What happens is, first of all, there is a need to try and see if the inquiry will seize upon the question of compensation. All of that work is often done pro bono by lawyers such as Howe & Co, myself and others, to try and in fact get the government, if the government is at the root of the scandal, or at least part of it as it is here, to try and engage even on the very basis of compensation. All of that work has to be done on behalf of a large number of people. One or two people lawyers can cope with on a pro bono basis, but you cannot represent people when you're talking about tens and numbers of people that gets up into the larger numbers. There is simply not the capacity for lawyers to do so. So what has to happen is that those lawyers make as part of their campaign the attempt to try and get government to engage on compensation issues. Let me tell you about the next stage. The next stage is when there is a bare acceptance that there might be a need to have lawyers on behalf of claimants, there's then a wrangle about how much they should be paid and about the hours they should spend on such matters. So the next stage is then fighting about how much it is that someone can have. On the other side, what happens is that the government, represented by lawyers, and indeed the post office, represented by many different firms of lawyers, is able to fund the payment for their hourly rates as they go forward. So you can see that there is an initial inequality that I'm afraid relates to the claimant side. Do you agree with that?
Yeah, I do. Yeah.
Now, you say in your statement this: your appointment, this is paragraph 8, sir, your appointment was manna from heaven to me because it meant I could actually help to fix something important. And you go on to say this: there wasn't a day, night or weekend that went by when I wasn't doing something on the post office redress schemes and transformation. So you understand how much hard work is involved in trying to get things moving in relation to these matters. And you understand that that type of work, that day and night work on behalf of people trying to get things done and fixed, is very difficult when essentially it is not funded at all. Do you accept that?
Totally.
Now, you've mentioned the question of working with schemes that don't perhaps on the government side, necessarily have the full engagement of an entire legal team, legions of lawyers working on their behalf. Could you consider this? In scandals such as the post office, whereby the government is part of the problem, the government owning the post office, the single shareholder, unless the government approaches the question of compensation with a spirit of generosity, there is always going to be a need to have lawyers on both sides, probably, fighting it out. Because without a genuine spirit of generosity in relation to the prospect of payment to those claimants, then essentially there will always be a fight, and the claimants will have to be represented.
Yes.
Now, Sir Wynne is left with the task, which I know he welcomes and looks forward to, which is the drafting of his report Drafting of this report will take place once all the lawyers stop talking, sometime through this year and into next year. Now, one of the matters that he has to wrestle with are questions of recommendations. We've had by now 2 other reports that touch upon how do recommendations get implemented. The Grenfell report and the Blood Inquiry report have both recommended that a committee of Parliament, probably a select committee, continues to oversee recommendations made by inquiries. And I'm not asking you your opinion about that. What I am asking you is this. Do you accept that there is a need for a body, probably such a select committee, to look at the question of how compensation is dealt with where scandals such as this take place, to learn lessons from what's happened in the past, from past inquiries, to consider how better the frameworks for compensation could be set up and managed in the future?
Yes, I totally agree with that. And we tried to kind of replicate that in a perhaps a less formal way with the Horizon Compensation Advisory Board. I wasn't seeking to criticise lawyers, the actual lawyers on either side of the process, actually. And, you know, we would never be here if it hadn't been for lawyers. This never would have come to light. And I fully understand that this is all done, as you say, on a pro bono basis. And as I say in my statement, this came to light because of Paul Marshall, and who was supported by Flora and lots of other people who did a fantastic job on a pro bono basis to bring this to light. So, I mean, they are, in many ways, you're the heroes of the hour in terms of making sure this came to light. I'm not just trying to be nice to you because you're asking me difficult questions. My point is really not that you shouldn't have lawyers on either side. In fact, you should have somebody in the middle. That's really my point. And I think this is what the National Audit Office has said. I don't think a select committee can ever play that role. It might do some oversight, or an advisory board can do some oversight, but you need somebody right in the middle who's not incentivised for this process to take longer. Because you and I would probably recognise that if you work for a large legal company, you've got an amount of hours to bill on a monthly basis. Maybe sometimes some of those things, those processes take longer than they might. So but if somebody in the middle can say, no, I'm not worried about that small element of this claim or that particular point, legal point you're raising, I'm taking a view on this exactly in the way you phrase it, so that it is generous and seen to be generous to the claimants who are involved in the scheme. I don't think you can do this just by lawyers arguing on either side. That's my point.
Yes. What I'm saying, the spirit of generosity really must come about because it is in situations such as the post office scandal, whereby at the heart of it there is a recognition that harm has been caused. That's the starting point for this inquiry. And so when we're talking about the spirit of generosity, it is in fact the balance. It's the repair or an attempt to repair that the harm that is being caused by one actor, in this case the government and its single shareholder status in relation to the post office. So it's about acceptance of this is what we've done. We're sorry about it being done. We're not only sorry, but we're actually going to pay up. I'm going to make sure we pay up with as open-handed as possible, bearing in mind public finances. That essentially is what should be embraced. Do you agree?
That's exactly what should happen.
Thanks, Hollinrake.
Thank you.
Ms. Ward.
Thank you. Thank you, sir. Good afternoon, Mr. Hollinrake. I'm over here.
Good afternoon. Hello.
Thank you. We have this difficulty every time I ask a question.
See you fine.
I'm going to ask a question on behalf of the NFSP, and I'm going to call up a document, and I'll give the number for that. But you might recall that on the 8th of January this year, just after the ITV drama Mr. Bates against the Post Office, the NFSP Chief Executive Callum Greenhow wrote to you, and that letter is WITN 00370106, and I'd just like to call that up. And if we scroll to page 2, and it's about halfway down the page, the paragraph that begins, postmasters are justly and rightly highlighting their concerns over the robustness of Horizon today. with the NFSP repeatedly calling for the system to be externally audited to ensure that nearly 5 years after Justice Fraser's Horizon Issues ruling, that the system is robust. Everyone, whether postmaster, assistant or Crown Office employee of the Post Office, still use Horizon today, and collectively we have to have confidence that the system works as it should and does not have bugs, defects or errors that secretly affect branch office accounts. Government, as the sole shareholder, should be ensuring on behalf of the general public that this is the case. We take that document down. The inquiry has also heard, I'm not calling this up, but I think you've referred to it in any event, has also heard about the results of the YouGov survey for the inquiry. That's EXPG 000000. I think it's another 0 and 7. And that indicated that 49% of respondents using Horizon at present were net dissatisfied with Horizon, compared to 25% who were net satisfied. And in addition, 57% of respondents had experienced unexplained discrepancies within the last 12 months. And in addition to that, the inquiry's heard evidence about the delays to the new branch IT system, NBIT. It's years behind now and millions over budget, and it's possible, it sounds like, that at the Post Office it may have to look even beyond NBIT. But certainly it's unlikely the Post Office is going to move away from Horizon anytime soon. So what I wanted to ask you was, would you agree that an external audit of the Horizon system is necessary? In other words, something that's completely independent to report back to everyone with an interest, involving and including postmasters?
That sounds very sensible to me.
To your knowledge, and following on from that letter of January the 8th this year, and appreciating that your knowledge may extend only to the 4th of July of this year, in light of this letter, has there been any proposal that you know of within Post Office for the current system to be externally audited?
I don't think that's something that we ever directly discussed, although we did discuss some of the concerns about ongoing discrepancies. And I mean, there are postmasters are dealing with cash every day. There will be discrepancies for it, bound to be some discrepancies. I think what the problems with Horizon were not just IT problems. They're also the approach of the Post Office in terms of their willingness to prosecute and their willingness to think the worst of postmasters. And it's my understanding that Post Office take a completely different approach to this. Instead of an adversarial approach to some money missing, it's an inquisitorial approach, which is, okay, you know, certainly giving the postmaster the benefit of the doubt, which you would expect to happen in this kind of network. So I understand that to be the case. It wasn't the case that anybody came to me when in my tenure as Post Office Minister to say this person's been taken to court. In fact, the Post Office no longer take forward private prosecutions, but he's been taken to court on the basis of evidence from a Horizon or something that is. So I never heard those concerns either from the NFSP or from others in terms of this was a live problem ongoing about these issues about discrepancies being then taken forward in terms of something along the lines of what happened with Horizon previously.
Although that point is being put in that letter, you would accept?
Yeah, and I do have no problem at all in an audit of the system. Clearly, I'm not the decision-making minister now, but that would seem sensible to me. It was the first time I'd seen the YouGov survey in terms of the pack that I read over the last few days. But on that basis of lack of trust amongst the network for that system, I think that would seem eminently sensible.
Okay, just to tie that off, can I take it from what you've said that the government, in your time, up to when you concluded your role, that the government as a sole shareholder hadn't asked the Post Office to conduct such an audit?
I don't remember us doing that, no. But we did ask questions about the approach that Post Office is now taking where there were discrepancies.
Thank you.
Can I detain you for 5 minutes?
Yes,
I think that's
certainly.
it, Mr. Hollinrake. It may be that I will need to form a judgment about the pros and the cons of the fixed offers that operate. All right, I'm not sure if I will need to do that, but just in case I do, since you were obviously very influential in their introduction, I'd like to get your view as to what are the pros and cons.
Yeah,
all right. I think I can identify as two pros: speeding up the payment of compensation, yeah,
Yep.
and in all probability, significant savings in legal and expert costs. Yeah.
Yep, that's true.
Can you identify other cons for me? Sorry, other pros for me before we get to the cons?
Well, as I said earlier, some people who would have got less than the fixed sum award will now get...
Well, that might be thought to be a con. So let's come back to that in a moment.
Well, no, okay.
Can we try and do it in
Okay.
that way? So we got speed of payment, and as I say, I can imagine that if you got an actuary or an accountant on it, they might be able to justify value for money in terms of saving in legal costs and all the rest of it. So those are what I see, at least, as the two major benefits of the scheme.
Okay.
Okay. The cons actually relate to the recipient, because it's not a con for Wyn Williams if my true claim is worth £5,000, but I get £75,000.
Oh.
It's a windfall.
Yeah, that's right.
Yeah? But it's a con also, isn't it, for the public at large if that happens.
I mean, the public at large pay more, you mean, in terms of the taxpayer? Yes.
Well, and there's a point about the fairness as between claimants.
Oh, you could definitely argue that some people would feel, well, you know, that person's getting more than they should, or the same as me. That person's only due £5,000, and I've got £75,000, and I was due that, and they've got the same as me. You could argue that.
Yeah, and then the other part of that thinking process is that people who are, shall we say, claiming £85,000 or £90,000 might well feel pressured into taking £75,000 because they know that if they don't accept the 75 at a point in time, it's lost forever, as the current scheme currently operates.
You could argue that.
Well, I think I would argue it if I was a lawyer.
I'd argue differently. I mean, I would say there is, of course, a case for that. So people might decide to take a view. And can I say, nobody's saying those people shouldn't have legal advice or other advice before they decide to take that.
But the point I'm going to come to is this, that in normal litigation, okay, set aside cost consequences, if you, the government, make an offer in a case of £500,000, then, except in those very rare cases where you withdraw it completely, it's always available to be taken, right? In this scheme, if you don't accept the 75,000 or the 600,000 at a particular moment in time, that sum is lost forever and you're on risk of getting less. Is that fair to describe as a downside?
Well, that would depend on the rules of the scheme. I'm not saying...
Sure, so that's my last question to you.
No, I don't say for a minute that somebody decides to go down the full assessment route and then is only offered, let's say, £60,000 rather than the 75,000. Would you give them the 75 anyway? I think you could
I was
argue that
being a
case.
bit more generous to the post office or the government, and simply going to suggest that why is it you've got to make a once and for all choice at a moment in time, as opposed to being able to say, well, look, I've now gone down the full route, but I realise that I'm on risk, and so I want to draw back and take the 75,000. What's wrong with that?
No, I don't think potentially there is anything wrong with that, and that could be a feature of a future scheme. And we had that discussion ourselves internally. Like I say, it was never the case I don't care how much this compensation scheme costs. Of course, we've got to have an eye on public money, but what is fair is fair. So if it costs, it's now the envelope, I think, is 1.8 billion. I don't care if it costs 2 or 3 billion. I said this to James Arbuthnot and to the officials. It was never a case of trying to save money. It was always a case of trying to expedite and accelerate the amount of compensation that goes to individuals. We never try to shortchange anybody, and the scheme should never try to do that.
All right. Well, armed with your views, I'll ask Mr. Creswell and your successor minister in
Please
due
do.
course what they think of that. All right. Very good. Thank you.
That is
Thanks
it.
very much, Mr.
My
Hollinrake,
pleasure.
for
Thank you.
your assistance to this inquiry.
Thank you. My pleasure. Thank you.
Thank you. So can we break until 1:30, please?
I've heard of truncated lunchtimes, but even by your standards, Mr. Beer, that was pushing it a bit. Yes, 1:30.
1:30, thank you.
Yeah.